Hello and welcome to Thought Chakra. So, we are going to read about a very important split verdict that has happened in the Supreme Court recently. So, in a two-judge bench of the Supreme Court, a split verdict has been delivered on the constitutional validity of the Karnataka Government Order, which placed restrictions on women or Muslim women specifically for wearing hijab in the pre-universities and colleges in Karnataka. So, if we are to go to the context, basically what happened is on the 1st of January, some of the Muslim girls were actually denied and they were denied to give their exams in a college in Udupi as the college ordered that hijab as a dress code went against the prescribed norms of the college. Actually, the real issue was that some of the MLAs they questioned the women, the girls wearing hijab into the college premise, and then he said that. The women, if they wanted, the girls, if they wanted to give the exams, they could take a transfer certificate and they could go somewhere else, because if they were to have be in that college, then they couldn't wear the hijab per se. The questions then were raised on the administrative involvement of the MLAs who were questioning the dressing, after which the Karnataka government got involved and it formed a expert committee to resolve the issue. So, what were the issues? Basically, there were two sides of it. The petitioner said something and the government said something. So, we'll look at that. The petitioners basically said that wearing hijab was a necessary religious practice. So, you have to be very careful while reading this, because the first initial argument given by the petitioners was that wearing hijab was a necessary religious practice under the Article 25, and that the action of the state government amounted to hostile discrimination based on the religion. So if the state government was telling that okay, you cannot wear hijab, so it went against a particular religion, so that shouldn't have been done. And then the Muslim girls also said that they were the least represented in the classrooms, and if they were to be shut out, it would further be a setback to their whole community, because anyway a lot less number of Muslim women were a part of the classrooms that they were in. In fact, senior advocate Devdutt Kamath, who represented the two girls, said that the ban would impinge the freedom of religion, which was guaranteed in the Article 25 of the Indian Constitution. So basically, all the arguments revolved initially from the Article 25 and then went on to the Article 19, which talked about the right, freedom of expression, as well as Article 21, which talks about the right to have a dignified life. So, what was the government's stand after that? The state government basically contended that wearing hijab was not an essential religious practice. So, what the petitioners said under the Article 25, they rejected it, saying that hijab essentially was not an essential practice. So, we have a non-essential part as well as an essential part, kind of a doctrine which the Supreme Court or the judiciary contends on, and says that the state government instead said that because hijab was not an essential religious norm according to certain interpretations of the surahs that they made, then they said that this couldn't be allowed. It further said that the practice must pass the test of constitutional morality and individual dignity as expounded by the Supreme Court in the Sabrimala case. So as we all know that the 9-judge bench judge in the Sabrimala, uska abhi tak verdict nahi aaya. So the case more or less was a subject of constitutional morality versus the individual dignity case, and the matter of hijab again should have gone through the testing process which involved this particular case. The state government then upheld the ban, saying that the freedom of religion could be subjected to reasonable restrictions under the constitutional provisions for maintaining an institutional discipline. So the government stated that under the Karnataka Education Act of 1983, wearing hijab was not allowed, and that under the section 133 of the act, it reserved the right to issue appropriate directions to schools and colleges to ensure that a proper public order was maintained. So then what happened? On the 15th of March, 3-judge bench of the Karnataka High Court, it upheld the ban which was given by the government, and then the petitioners, what they did is they went to the Supreme Court. Since today's verdict was actually, which was reserved after a 10-day hearing, it is a split verdict. The entire issue would again be reinstituted in front of the Supreme Court with the larger bench, which will be decided by the CGI, which is UU Lalit, who is the master of the roster. So the verdict that was given today, basically a split verdict. What were the questions which the petitioners actually questioned were? The questions, and we would also know what Hemant Gupta as well as Justice Dhulia, what arguments they gave. So basically the petitioners questioned on whether the Karnataka government could order, or the order that they gave was actually a violation of the constitution or not. This was one of the questions. The second question was the right of the students, like the students' right, which came under Article 19, where freedom of speech and expression was involved, as well as Article 21, where a right to live a dignified life was involved, as well as the most important, which was their initial argument, which is the Article 25, which protects the right to profess religion, was involved. Now, the two girls also contended that denying the right to wear hijab actually denied them the right to give exam, which in turn was against the right to education, which is guaranteed under Article 21. So it is basically a combination of a lot of rights which they were talking about. Also contended further that the right to conscience was also violated under Article 25, and that under the Article 21 the right to privacy was also violated. So a lot of questions, around 11 questions, which we have been told that there were around 11 questions which were given by the petitioners, all of which was rejected by Justice Gupta, stating that these questions by the petitioners, they were not valid, considering that the interpretation of and basically what they also said is that the Karnataka government could have delegated this power to the college development committee, and this kind of restrictions could have been imposed, or they could have looked into this matter, is what the petitioners were saying. Now, Justice Gupta, what he did is he rejected all the questions by the petitioners, saying that since hijab, according to the interpretations of the surahs, were actually not an essential practice in Islam, that is why all the cases that were being heard, or all the questions that were being given by the petitioners, were not actually valid, and that he actually accepted, or he upheld the judgment which was given by Karnataka High Court as well as the Karnataka government. Now, Justice Dhulia had a very different stance. According to him, Article 25 was nowhere involved in this particular case, which however was the initial questioning which was made by the petitioners. He actually said that in this particular matter, what we have to look at is the Article 19 and its relevance, as well as Article 21 and its relevance, saying that since Article 19 talked about a right to freedom of expression, and hence wearing of hijab or not wearing of hijab was actually a matter of Article 19, and that Article 29, which actually verdict gave the right to a dignified life, was actually the things that should have been in question. And as we all know that Article 20 also contains about the right to education. So since basically the women, not only the Muslim women, but the women in general, or the girls in general who belong to the semi-urban areas, वहाँ पे education already उनको बहुत ज़्यादा कम मिल रही होती है. So that this particular case shouldn't be looked from the eyes of Article 25, which talks about right of conscience, or which talks about the essentiality of some practices being a part of a particular religion or not. It was actually an error on the part of the High Court to go into the Article 25 if hijab was an essential practice or not, which was futile. He stated that it is more important to look at the situation of the girl child, especially in the rural urban areas or the semi-rural areas, where women actually do not get the enough freedom, so that they can, lead a life where they are given the opportunity to educate themselves, or to grow in their society, or to climb up the ladder. So instead of seeing it from a religious angle or from a political angle, it's that it should have been looked after from a very logical point of view, where education was involved and the right to education as a point of view was involved. So with this split verdict, what do we have to read from the exam perspective? So from the exam perspective, I would say that knowing what actually a split verdict is would be helpful in this case. So let me read out to you. Basically, a split verdict is passed when a bench cannot decide one way or the other in a case, either by an unanimous decision or by a majority verdict. So split verdicts basically happen when there are even number of judges involved. So split verdicts can only happen when the number of judges are even. That is why usually the sit benches are the benches which are given by the the CGI. They involve odd numbers, which includes 3, 5. There would be 3 judges or 5 judges or 7 judges, even though in important cases there could be somewhere around 2 judge benches as well. Okay, so these judge benches are known as the division benches, which are not uncommon, but still in case where they need an actual verdict, then mostly the split verdicts happen when there are even number of judges, and when we want a decision to happen, then we have an odd number of judges in a bench. In case of a split verdict, the case is heard then by a larger bench. The larger bench to which a split verdict goes to can be a 3-judge bench of the High Court, which in this particular case can be the possibility, or an appeal can be preferred before the Supreme Court. In the case of a hijab verdict, the CGI, who is the master of the roster, will constitute a new larger bench to hear the matter. Now it is to be seen that whether it would be a 3-judge bench or a 5-judge bench. So what if we talk about the earlier cases with a split verdict? So in May, a two-judge bench of the Delhi High Court delivered a split verdict in the batch of petitions challenging the exceptions provided to marital rape in the Indian Penal Code, where Justice Rajiv Shakdher held that the exception under the Section 375, which deals with rape of the IPC, is unconstitutional, while Justice C. Hari Shankar, in a totally opposite argument, said that the provision is valid. So, if we have to talk about another case, then among the other cases would be the split verdicts delivered in the Madras High Court Division Bench, which ordered on a challenge of the disqualification of the AIADMK MLAs owing to allegations to the TTV Dinakaran in 2018. So that's all for today. How did you like the video? If you want to have more such articles coming up or more such discussions coming up from our channel, mostly related to current affairs, this would in particular be a part of the GS2, and we would be waiting further for the further arguments which have to come, or further verdicts which will be coming, or further what all happenings are happening for this particular case. Then do subscribe to our channel. Do let us know in the comments if you like the arguments that we gave in, and follow Thought Chakra. We are focusing largely on polity initially, but we would be going for more such subjects in the future. So bye bye and take care.